community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Good afternoon, ladies and gentlemen. You're welcome to Hanging Out with BWF Solicitors. With me, your host, Vicky Newton. Today, we're going to discuss something about administrative review. Is administrative review an option as a student whose application for entry clearance has been refused? That is what we're going to discuss today. Before I introduce Lawyer Eunice to you, I would also like to ask you to please share this program to all your contacts for them to also benefit from this program, because trust me, you're going to learn a lot from today's topic. You can follow us live on Facebook, YouTube at BWF Solicitors. If you prefer to contact us during the show with your questions, you can do so on our Facebook and YouTube page or the designated number 0744 8619 711. The number again is 0744 8619 711. Once again, you're welcome to today's show, Hanging Out with BWF Solicitors. Lawyer Eunice Achampong is a partner at BWF Solicitors and also a seasoned solicitor. You could see she's a very young lady, very impressed with her hard work. And, you know, any case that she touches, trust me, she's successful with it. Lawyer Eunice, you're welcome to today's program.
Thank you so much, Vicky. How have you been?
Yes, I've been good, and I've been really looking forward to today's show. I think today you've got a bit on the, you know, administrative review issue. Yes. I'm super excited about, you know, today's topic, something different. And before we, you know, talk about today's topic, as you usually do, you take us through, you know, the updates for people to be abreast with what is, you know, happening in regards to the Home Office. So if you could please do us the honors and take us through, you know, should we say the gossip?
Yes, a bit of gist. Yes.
Yes, Lawyer Eunice is going to give us the gist. Yeah.
Yes. So I wouldn't want to take too much of our time. As Vicky has already mentioned, there's always updates when it comes to the Home Office, and it's good that we keep abreast with what's on currently on as the government will have it. And then it's important that as much as possible, we make people aware so that it can be shared amongst other viewers and other people as well. So let me first say happy weekend to our viewers from wherever you are watching us. I hope that by God's grace, you're all doing well. And I also hope that as this month is coming to an end, everything has worked out for you. I know there's so many things going on. The kids were telling me about Black History Month, and we at BWF Solicitors were also making viewers aware of our breast cancer awareness as well, and the fact that cancer research has themed it as the second phase awareness. And so when we say second phase, they are saying that this is when the cancer has spread throughout the body and there is no cure. And so they are making people aware that this is something that they should be checking even before it becomes uncurable. So as awareness is being put out there, obviously people will have to do their body checks and make sure that this is something that they are checking around the breast area, around the nipple area, just to make sure that things are okay. And if you, for any reason, feel a lump or anything that is odd, you have to speak to your doctor. And if further tests need to be run, then they will do so, so that at least it is treatable at that first phase or first stage. So it's something that we are making our viewers very much aware of, and hopefully the general public at hand will keep doing so, just to make sure that people don't keep dying, or it is preventable at some stage. Yes.
May I also add to what you just said? I think we also have to also make the men aware as well that they also can have cancer, especially with prostate cancer, which is very, very, very common of late. So please, as the women are checking their breasts, checking their body, please, please, please also check your bodies as well, especially in regards to prostate cancer. I think there are some test kits that they can use to check whether they are safe or there is any suspicion of or traits of prostate cancer. So that's what I'll add to what Lawyer Eunice said.
Yes, yes, it's very important that our men do check this, and apparently they also do have men that have breast cancer as well, and it affects quite a few men. So this is something that they should be aware of. So yes, I really do hope that our viewers will catch on to this and will also take note. Yes. Okay, so to our updates as we usually do. In terms of general home office updates, when it comes to our fees, I know that a lot of people have been asking about the fact that when the fees increase, has it had much effect? We did broadcast it from the 4th of October and even before that they were going to increase entry clearance fees, nationality fees. I know that the home office fees remain the same, but they will be increasing the immigration health surcharge on the 16th of January 2024. So anybody who is not applying to come into the United Kingdom as a person who is coming with indefinite leave to remain, or somebody who is already in the UK and is applying for indefinite leave to remain may or will not have to pay this immigration health surcharge. It is only applicable to those who are applying for leave to remain, leave to enter, or further leave to remain in the United Kingdom, in whichever category you are applying for. So most of the time, most people will make an application and they will have to pay an immigration health surcharge. I know those that work in the health sector don't have to pay that because of the discretion that they have been given by the Home
Yeah,
Office not to
okay.
pay immigration health surcharge. So this will not affect those working within the health care sector who have health and care visas or skilled worker visas. But it will generally affect most people in the different routes, such as family life, student, skilled worker, global talent, skill up, innovator, founder. Um, a lot of the routes that we have applications made on will be affected by the increase in the immigration health surcharge, which
Okay.
is now going to increase from £624 to 1,300 sorry 1,035.50 in the coming year. And then those who are children always have a discounted rate, so the children will have to pay 770 for each year, whereas now they're paying 470 for each year. So of
Hmm.
course, um, that is about double the amount that an adult would have had to pay, or double the amount that the child would have had to pay. So obviously, it's a big jump. But if
Mhm.
you feel that you cannot afford the fees, there is still fee waiver applications available for those who are making applications within the UK. I know
Okay.
that those outside of the UK would have loved to benefit from a fee waiver application, but unfortunately, most of these fee waiver applications are only for leave to remain or further leave to remain applications
Right.
here
Okay.
within the UK. And that takes me on to a very interesting case that came out just a couple of weeks ago in regards to a young lady who came here as a student.
Mm-hmm.
It's in regards to a case called PA and others. And of course, she came here knowing very well that she would not have recourse to public funds because they expect you to be able to pay the fees and also to
Yeah.
maintain yourself when you come. And that is part of the requirements when you are applying to come as a student. So she was
Okay.
very much aware that she would have to be able to maintain herself and also pay her fees whilst in the UK. But here's the case that she uh, got pregnant even before she came, and she had her baby, and now she was stranded because she had no means of um, working and also schooling and also taking care of the baby. So
Okay.
obviously she tried to make an application at the time to um, have further leave to remain based on her child here in the UK. That didn't work out, and she wanted recourse to public funds
Right.
because obviously things were difficult. And it came to the point where she said, "There's no way I would be able to maintain myself and my child when I am um, literally destitute. I don't have
Mm.
the means to even cater for my essential needs, and neither can I take care of this child as well." And of course, the court looked at it and said, yes, we know that the general rule is that any immigrant or any migrant who is coming into the UK should not be given access to public funds or should not have recourse to public funds. But here's the case that she's unable to even care for herself. So in this case, we're saying that she's basically destitute, and there are compelling reasons why she should have access to public funds. And the court agreed with her and said, yes, she is destitute. She meets the destitute test. And
Mm.
because of that child, it is important that she has access to public funds.
Mm.
And so Just last week, the Home Office also came in with their guidance to say that because of this case of PA and others, they are now going to give students, skilled workers, domestic workers,
Mhm.
most people within the skilled worker routes will have access to public funds if they can show that they have dependent children and they will be destitute, or there are compelling reasons why they should be
Mm.
given access to public funds. And so, obviously, that has opened the floodgates for many other migrants to be able to apply for the no recourse to public
Public
funds to be lifted or to be removed from their leave if they are struggling to literally provide their essential needs. And so I think it is good news for those on the skilled worker route or as a student, and they're thinking, I will not be able to go on if I don't have access to public funds. So
Mhm.
this is some good news for those on that route as
Okay.
well. Yes. When it comes to our, I know that when it comes to our children here in the UK as well, those of them that have come from abroad, they are also able to apply for fee waiver. So
Mhm.
it is only exclusive to children under 18 whose
Okay.
parents do not have the means to pay for the application for the child to come into the UK. So, if you are looking to make an application for your child who is outside of the UK to come into the UK, there is the possibility of them being able to apply for fee waiver as well if the need arises. And so, obviously, with applications like that, I always say that it's good to see a solicitor or a lawyer who is well versed with the law and applications like that so that they can help facilitate the whole process as well.
Mm.
And then, thirdly, um, when it comes to our biometric residence permit, I know a lot of people keep saying they don't understand why the card is coming to an end on the 31st of December uh,
Mm.
2024.
Mm.
And I think we will keep announcing this until next year. The
Mm.
reason being, the government have already stated that they are phasing out biometric residence permits. So if you have a biometric residence permit card, you
Mm.
should know that it is going to come to an end on the 31st of December 2024. They are phasing them out and they want everything to be digital or to be electronic. So no longer would you be having the card. And because um, most, should I say, ethnic minority people are so used to having the card, they feel like if they don't have the card, then they've lost their immigration status in the UK. And
Mm.
unfortunately, that is not how it works, because once you've been granted leave, if your leave was granted this year, the likelihood of your leave expiring probably in 2025 or 2026 is very high, because usually most people are granted leave for 2 years, 2.5 years, 3 years, or more. And so you cannot go by the date on the card because the card will give you a wrong date.
Date.
You will have to go by the date on the letter that was given to you once the Home Office granted you leave. So if
Mm.
the Home Office granted you leave of 3 years or 4 years, and you are saying that yes, I've been granted leave of 2.5 years or 3 years, the letter states clearly that you have been granted leave from 1st October 2023 to let's say 24th June of 2026. And so
Mm.
that is the dates that you have to go by. The card is only an indication for you to know that if you have somewhere to go to. For instance, if you're traveling, then you will need that card to show. Now,
Mm,
most employers, most estate agents can do a check online. And so if they have to do a check online to see if you have the right to work or the right to rent or whatever the case may be, they can do that with your details. Either you share a code with them to be able to check your details, or they can use your application unique number to check your details on the website to make sure that you have immigration status to continue to work and rent and do other things here
yeah.
in the UK. So it's important that we keep those home office letters and that we become more abreast with technology. I know
Mm,
some of us don't like using computers, but we need to now start doing things online so that it's a little bit easier for us. And
mm,
of course, people have said if I travel and I don't have a card, what are they going to do? They wouldn't do anything because they can now check um, your details online. If you
mm,
want, you can always carry a copy of the home office letter, or you
mm,
can just
mm.
have it readily available on your phone so that it's easy to show on your phone as well. So that
Yeah.
is another thing that I just wanted to mention to our viewers. So I'll leave the updates here and then we can continue.
All right. Thank you so much, Lawyer Eunice, for those updates. I've really taken notes of some of them. Yes. So, ladies and gentlemen, if you've just joined us, you are at the right place. This is hanging out with BEWF Solicitors, your number one law firm in London. They specialize in family law, immigration and nationality, Ghana law and practice, dispute resolution, just to mention a few. After this program, Lawyer Eunice will leave her details for you to, call her, book an appointment, and speak to her about any issues you might have. Today's topic it is administrative review, an option as a student whose visa application has been refused. Lawyer Eunice will take us through this discussion, tell us what really is administrative review and the necessary steps to take. If you want to join this discussion or ask any questions, of course, I would like to hear from you. You can do so on all our social media handles, especially on Facebook and YouTube at BWF Solicitors and also VK Newton. If you would prefer to contact us on this phone number as well, you can do so. It's 0744 7819 0744 8619. My apologies. 0744 8619 711. The number again is 0744 8619 711. You can send us WhatsApp messages or give us a call during the program. I will advise you give us a call probably towards the end of Lawyer Eunice taking us through the steps to take in regards to this topic so that it wouldn't interrupt in her explanation on this topic. So I'll get back to Lawyer Eunice. Lawyer Eunice, are you there?
Yes.
Good, 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 good. So Lawyer Eunice, one may ask, what really is administrative review?
So it's an interesting topic because I know that a lot of students will be making applications to come into the UK. And we already know from uh, the previous month that if you're a student, unfortunately, from the 1st of January 2024, you wouldn't be able to bring your dependents unless, of course, you started your course in September of this year, and obviously that option will be available to you. But if you are a student who is starting your course from the 1st of January 2024, then unfortunately you wouldn't be able to apply for any dependent partner or children to join you here in the UK. And if you are saying that you are studying a PhD course or a master's, which is research based, so when they say it's research based, it has to be more than 50% of your actual total course uh, grades or scores, that is going to be based on research. So those are the only people or the only students who will be able to bring their dependents with them. And if you are making an application to enter the UK as a student, there will be certain requirements, such as you being granted a CAS, that is your certificate of acceptance of study from the institution that you are saying that you are coming to. And they will expect that you meet the English language test and that you also can maintain yourself and pay the fees when you come to the UK. So, of course, if you don't meet any of these requirements, definitely will be refused. You may meet the requirements, but they may refuse you if they also feel that some form of deception was used in gaining your visa. So it could be that your application was refused whilst you were back at home, or it could be that you've managed to get the visa, you've entered the UK, and now at the airport, they're questioning you about a document that was part of the documents you provided, and they're telling you it's not genuine, we're going to cancel your leave, and therefore your leave is cancelled right at the airport. And you're thinking, what do I do now that my leave is cancelled? Because then it means that even though I'm here, I can't really do anything in regards to me continuing my stay here. So it's one of those things that a lot of people will think, what are my options? An administrative review, as we've mentioned, is when you say to the Home Office that you have made an error or you have basically made the wrong decision in regards to the cancellation of my leave or in regards to the refusal of my leave. And this is an eligible decision that you should have obviously taken seriously, maybe because you didn't do your work properly, which is usually called a case working error. So maybe you didn't look at the documents properly enough, or you didn't verify the documents enough, or maybe it could be that they didn't apply the law as they should have. And that is what we call a case working error. So if you do believe that there has been a case working error in terms of the refusal or the cancellation of your visa, administrative review is just to say that we want you to review the decision again and make another decision in regards to this refusal. And so, most of the time, if there has been a cancellation or a refusal, either that they will say, yes, we know that we made a case working error. Maybe we didn't verify the documents, or maybe we didn't look at your documents as a whole, or maybe we didn't apply the law properly enough. And therefore, it is important that we review the decision and then withdraw what we said before. Or it could be the case that they review it and they come back with the same conclusion, and they're telling you, we made the right decision, we are not going to change our minds. They might even add more reasons for refusal to the decision they made, or literally come up with a whole different refusal altogether. So those are the outcomes that usually will proceed from an administrative review if you do want to apply for one.
So, Laura Eunice, how long does it take for the review to be concluded?
Usually, they say that it's supposed to be a rough number of weeks, but
Right.
it never takes weeks. It takes more than even 6 months. And so,
Oh.
yes, for some, it can even take 9 months to a year.
Hmm.
Yes, because I have cases where the administrative review has taken so long. It has taken over a year. And
Hmm.
people think, what's the point? Because it's a long process. And I know, obviously, if you don't have that time, you wouldn't want to go through that, because it's supposed to be something that's quick and
Exactly.
very, shall I say, very easily processed. But
Hmm.
unfortunately, I believe that the same caseworkers who are the ones working on at the applications are the ones who are being told to do administrative reviews. So the caseworkers may be a bit overloaded with caseworking, and that's why it takes a bit longer than usual.
All right.
Yes.
Okay. All right. So, which eligible decisions can be reviewed if an application has been, made outside of the UK?
Okay, so when we talk about eligible decisions, we're basically saying what decisions are, um, should I say, can be factored in terms of administrative review, because not
Mhm.
every decision can go forward uh, through administrative review. So,
Yeah.
for instance, you may have done a visa application, and you're saying, oh, okay, can I go through administrative review? You will not have that option. So unfortunately, if you make a visitor's visa application, you wouldn't have the option of applying for administrative review, and you may not even have the option for appeal either, because you may not have any human rights claim in there. So, based on our Immigration Act of 1971, most cases that are based on human rights claims, and those that are either humanitarian protection or those that have uh, applied for asylum, will be able to apply for appeal as well. But
Yeah.
when it comes to administrative review, the government have said that most applications made as a student or under our points-based system, such as the skilled work route, global talent, ancestry route, all those applications will have the ability to apply for administrative review.
Mm.
Of course, if you have the right to apply for administrative review, then they expect that you will go through the whole process as successfully as can be. Um, when it comes to students, we know that the student route was renewed in 2020 when we decided to leave the European Union. So there was a lot of talk by the then government that there was going to be a new points-based system,
Mm.
and
Yeah.
under this new points-based system, it will open up the UK to the outside world, so that people who wanted to come and live and work will come
Mm.
here
Mm.
to work if they are able to accumulate 70 points on whichever visa route they were applying on.
Right.
And the student route was one of them. And the student route meant that you have to have at least 50 points based on the CAS, which is the
Mm. Mm.
CAS,
That's
and then another 10 points for your English language, and another 10 points for maintenance. So if you were able to um, obviously meet the required points to be able to make the application, then you could come into the UK, and then also you would be able to apply with your dependent spouse and child as well. So from October of 2020, if your application was refused as a student, then you would have the right to apply for administrative review, just in case you believe that there was a caseworking error by the caseworker who was processing your application. So most points-based system applications will have the option of administrative review being available if they didn't have the option to appeal, and most of them don't even have the option to appeal. So the only regress or the only way they would challenge the Home Office refusal or cancellation would have been through administrative review anyway. Yes.
Okay. Lawyer Unit, is it permissible to apply for administrative review for a dependent, probably a child or a partner?
Yes, I would say that it is to a degree allowed up to, I mean, by next year, 1st of January, we will see which people will be eligible to apply.
Okay.
But for now, it is open to all students and dependent spouse and child or children who have applied to come into the UK. So if you're saying that my application has been refused and my spouse has also been refused, or my child who made the application with us has also been refused, they will all have that right to apply for administrative review, because it is an eligible decision that can be reviewed as well. And just to make sure that people are aware, it is not free of charge. You have to pay a fee of £80 for administrative review to be carried out as well.
Okay. All right. Yes, we've got Kelly who is sent in a question. Says, "Good afternoon, ladies. I really enjoyed this show." Thank you, Kelly. I have a cousin who applied for a student visa, and when he arrived in the UK, because he was advised to carry the documents he used for the application, he brought them with him. He was interviewed at the airport and was asked a series of questions. He told them he was carrying the documents with him. They informed him they were going to detain him because one of the documents presented was false and that his leave had been cancelled. He was very devastated to hear this and phoned a friend who got in touch with a lawyer to apply for immigration bail. Can he still apply for administrative review? And Lawyer Eunice, will you be able to help?
Oh, bless. Okay, so here's a case where somebody has come through and they're basically being questioned over a document that is said to be false. Obviously, once you've made an application, the Home Office still has a right to make you aware that they will give you leave to enter. So just because your entry clearance application has been successful, you've been given the visa, does not mean that the border force, which is the group of immigration, or should I say Home Office officers who work within the airports and at different ports, that does not mean that they cannot also question you in regards to the application that you have made. And so once you enter an airport, you are given leave to enter, which is you're given permission to enter the UK officially. So if you have been granted a visa and now you're being questioned about your application, it is because they want to make sure that everything was given to you and was granted to you as it should have been. And so here's a case where this cousin of hers has been detained and literally has been stopped at the airport and interviewed. Of course, the Home Office or the UK Border Force that work within the airports and most ports in the UK will have to find out if your documentation is as accurate as can be. And so if they've gone through your documents and maybe they've checked against other bank statements that have come from that same bank and they've realized that there's something odd about this bank statement, or it could be that they do have um, contact details for this bank and they have contacted the bank and the bank has verified and said, well, we don't have any person with this account number and this name. So we can't verify the documents that you have at hand. And if that is the case, then it means that they will be coming back to tell you, well, your documentation is false, and therefore we cannot allow you to enter the UK as you were permitted by your entry clearance. And so that will give them the right to detain you, because if they've cancelled your leave, then it means that you have to go back home. But if, like she said, the lawyer has been able to apply for immigration bail and this person is granted bail, then they can look at ways and means to challenge the decision that the Home Office has made. If they are saying that, well, maybe the bank statements that I have are genuine documents and this is the bank that I've always used, and these are statements from previous months or previous years, and this is the bank that I know, and so you can't tell me that this bank statements I've presented is not genuine, then go ahead and challenge them through administrative review, so that at least they don't have uh, um, the idea that you were deceiving them. Because when we say that you've used deception, it means that you had the intention to present false documents or to make false representation, and that has obviously been detected by them, and therefore they will look very down hardly on that. And when it comes to uh, refusals based on deception, you have to be very careful, because any application that you make after can be refused on that same basis, and then a
Mhm.
10-year ban will apply as well. So it's important that we do make sure that as much as possible, if we have any documentations that we are carrying with us, that we are also able to verify those documents as much as possible, so that if the case is that maybe um, I can get a letter from the bank to say that I am a customer, I am an account holder, you can easily get that as well before entry into the UK.
Lawyer Eunice, is it compulsory to have those documents, physical documents with you?
Well, it's not compulsory. Some people do want to have it on them just in case they are questioning and then they don't remember
Oh
the
my
account
goodness.
details.
Okay, right. Because it's
So
this physical document that has caused all
yeah,
these. Because they
yeah,
have all that information
yeah,
electronically. But presenting those physical documents
yeah,
created the confusion.
yeah, yeah. And I think that because sometimes, unfortunately,
Hmm.
our memory doesn't serve us well. So we want to hold on to the documents just in case. Of course, we are making another application here in the UK and we can't remember what was said previously. So somebody may have a previous copy of the application
Right.
and then document, because they just want to make sure that everything that was presented before is the same thing that will be used in their next application as well.
Mhm.
Obviously, we wouldn't need the same bank statements because you are now in the UK.
Exactly.
Other documents, if you were married, for instance, yes, you would definitely need the marriage certificate and all of that in terms of
Mm.
making a subsequent application. So I guess some people still hold on to those things because they don't want to make a mistake. But when it comes to um, obviously keeping and retaining information, many of us are not very good at it.
All right, so we have to work on that. It's very, very
Yes.
important, or else it's going to get us into trouble.
Many people are not good at retaining information. You ask them, and it's all over the place. It's not great at all.
Someone might say that, oh, my real name is so and so, but people usually call me so and so.
Yeah,
Protecting yourself. Oh my days. Oh, all my friends call me by this name, but my name is, which is
yes,
different.
yes,
You
yes,
know.
yes.
Oh my days. Don't worry. We'll work on that. We'll work on that. Yeah, there's more room for improvement. That is
Yes,
why this show is,
yes,
here.
yes,
Educate people, tell people their mistakes, how to get things right, so
yes.
that when there's any application, you will not be found wanting.
One thing,
So it's a
yes,
very good point. Lawyer
yes.
Eunice, I've got another gentleman, Mohammed. He says, in case where the student arrives with a spouse and they are both detained, if
Mm.
possible, can they also appeal the decision to cancel their leave?
I know when it comes to a spouse application, most of the time the spouse would have come in with the same student visa that the her husband has got.
As
So
well.
if, for instance, we were saying that the spouse and the student himself have been detained, unfortunately, because most of these applications have only administrative review as a form of redress, it is very unlikely that they will be able to appeal the decision because, as I mentioned, an appealable decision will be a decision where a human rights claim has been put in because maybe you have a right to family life with somebody who is already in the UK,
Yeah.
or you already have a child or a wife or a spouse here in the UK, or it could be that you are making an asylum claim, and therefore, if your claim is refused, you have a right to appeal.
Appeal.
Obviously, those who are also under the EU route will also have a right to appeal as well. So it's very limited in those cases if you
Mm,
were to go for an appeal. So if
okay.
the husband and the wife are both detained because, for one reason or the other, maybe a document has been found to not be genuine. And just for our information, they don't have to just check the physical document to verify it. Even if it's a scanned copy, they can
Okay.
still verify it against other documents that they do have available on their database. So if they have all the details available, they can still call the bank and check, do you have anybody with these account
Right.
details?
Right.
And they will still be able to do their
Mm,
checks even without the physical document.
okay.
So when it comes to a husband and wife, unfortunately, they wouldn't be able to appeal the decision unless there's a human rights claim, unless they're saying, well, maybe we also have a child who is already in the UK and
Mm,
they've lived here for 7 years, for instance. So we want to make that claim based on this child who's already here in the UK, or we want to basically go ahead and apply for bail because we have enough evidence to basically say to this case working team that they haven't done their job properly or they've
mm,
a case working error. And so, in such a case, we all know that the Home Office has to give the person the opportunity to also counteract what they're saying. And that's what they term as minded to refuse. And when you're minded to refuse an application, the caseworker has to bear in mind that they have to give the student or the person that has had their leave cancelled the opportunity to also come back and refute the claim that has been made
Right.
the Home Office as well. So yes,
Okay.
they would have the opportunity to do so once they've been granted immigration bail, and of course, once that has gone through, they can make their application for administrative review. So it's highly technical. I always say that anybody
Mm,
who is
mm,
doing this should seek
mm, mm,
legal advice.
mm.
If you are making an application to switch to any other route whilst you are waiting for administrative review, know that that application will then cancel out your administrative review. So, um, if you are making such an application, please be minded that if you do make that application, then it means that they can just come back and say, well, you put in an application, so we are no longer reviewing our decision because
Mm.
of the application that you've now put in. So that is something that has to be
I
considered.
think MFA asked this question. You've already answered it. That what if the administrative review is unsuccessful? Now, what I want to know
Mm.
is it only on human rights grounds that you may have a right to at least have the chance to, be successful with this administrative review appeal? Is it only on human rights grounds?
So if you are appealing instead of going through administrative review, because our Immigration Act of 1971 is very clear about what an appealable decision is, it makes it very difficult to bring an appeal or to lodge an appeal where there
Mhm.
isn't any human rights claim or
Right.
humanitarian
Okay.
protection claim. So apart from those, the court will tell you that they don't have any jurisdiction to hear your case because
Mm.
there isn't any uh, human rights claim or there isn't any humanitarian protection claim that they can actually see to have been made in your case, and therefore
Right.
um, they are likely to just throw your case out the moment you lodge it, unless you can say that yes, I've made a human rights claim because maybe, like I was saying, you have a child who's already in the UK. They don't have to be British. Maybe they've been here for the past 7 years, so it means they've lived
Mhm.
here 7 years continuously. Or it could be that you are making the claim on the basis that you've now detected that for some reason or the other, they haven't obviously looked carefully at your documentation because maybe one of you has ancestry that's British and you are also claiming uh,
Mm.
British or something of that sort, and therefore they should look at the fact that the main student may have a claim in terms of your human
Right.
rights. But if there isn't any human rights claim, the only other option will be administrative review.
Okay.
So it's important that if you believe that you have a human rights claim, then of course you make them aware of that, um, even through the process, so that they are aware that okay, let's give you a chance. We'll not detain you. We'll let you go, and we'll invite you back to another interview to make your claim clear to us.
Okay. All
Yes.
right. Thank you, Lawyer Eunice. I think all questions have been answered. All too soon, our time is up. Lawyer Eunice, will you just summarize everything, just for the benefit of those who've just joined us halfway, through the show? So if you could give us a brief summary, then most importantly, your details and address, office address, for anyone who would like to book an appointment and pay you a visit in the office to discuss any issues with their sorry, I was going to say administrative review with their immigration, problems.
Yes. Okay, so just a quick summary. We've just been talking about administrative review being an option for anybody who has made an application for a student visa to come into the UK. And if for any reason you made the application with your dependent spouse or partner, yes, you will have the option of having a redress through administrative review. Yes, the decisions that are made are not appealable decisions if they do not have a human rights claim or humanitarian protection claim. But you will have that option to say to the Home Office that maybe you've made a case working error because obviously the decision was based on whether I meet the requirements, and if for any reason they haven't gone according to the law, or they have said that you have used false representations, then you need to be able to provide them with your reasons why they have made a case working error in that case. So of course, that option is available whether your leave to enter the UK has been cancelled at the airport or whether your um, application was refused in your country of origin. So it's just a quick summary. Of course, if you do need further advice, you can contact us at BWS Solicitors. We are situated on the fourth floor of Anna House, 214 to 218 Tottenham High Road, and our postcode is N15 4NP. So N15 4NP. We open our offices from Monday to Friday from 9:30 a.m. to 6 p.m. Our office telephone number is 0208 493 7340. And our out of office number, or my number, is 075 35813910. If you have any other issues apart from immigration issues, because we do deal with family law matters and civil litigation matters, as well as probate and drafting of wills, you can also phone us and then have a consultation booked to also have advice in regards to these services as well. So, yes, let's see what we have up in store for you next month as well.
Okay, thank you so much, Lawyer Eunice. I would also like to add that BWF solicitors have another interactive program on Facebook at 4 o'clock. Is the Community and the Law, is hosted by Mr. Oreku Frimpong, and guest is the overall head of BWF solicitors, Mr. Bernard Owusu. It's very important what they are going to discuss. I'll also tune in at 4 o'clock. I think what they are going to talk about is, do you know that your extra love affair can lead to the revocation of your British citizenship? I never knew that. Honestly. There'll be so many people who will be stripped of their British citizenship.
Yes.
Honestly. Wow.
Yes. Yes.
Ladies and gentlemen, I can't wait to join at 4 p.m. I've got a lot of questions to ask. So please join in at 4 p.m. on BWF Solicitors Facebook page, entitled the Community and the Law Program, arranged by BWF Solicitors. You know that certain mistakes people do that results in their citizenships being revoked. So please tune in and educate yourself on what mistakes can, result in your citizenship being revoked. On that note, thank you so much for joining us in the program and contributing to this program. We very much appreciate it. Don't forget to share after this broadcast on your, social media handles, Facebook, YouTube, wherever you can share this program. We hope to see you another time. Take good care of yourself and stay blessed. Don't forget to check yourselves, because it's in a Cancer Awareness Month. So please do check yourselves, including the men. Check yourselves to make sure that you haven't got cancer. Take good care of yourself and stay blessed. Bye-bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right results and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.